we were scheduled for a jury trial. However, there's been new evidence that there's no way the state would have known or the defense would have known. Is that correct for both parties?
Yes, Your Honor, we found out about it, or I really found out about it along with the defense yesterday.
And I think the scope of what we needed to both see was great.
Buckle up, guys. Today, we're stepping inside a courtroom where everything changes in an instant. What begins as a routine jury trial suddenly takes an unexpected turn when shocking new evidence surfaces, evidence that neither the prosecution nor the defense ever saw coming. The atmosphere shifts immediately. Tension fills the courtroom as both sides admit they're unprepared for this surprise development. What should have been a straightforward legal proceeding quickly transforms into a far more complicated battle, leaving everyone scrambling to understand the full impact of the newly discovered evidence. As uncertainty grows, it's clear that this revelation could reshape the entire case. With both attorneys forced to adjust their strategies on the spot, the courtroom becomes the stage for a legal showdown where every decision from this point forward could change the outcome.
To our investigator, the jail said that they would compile the list of visits concerning Mr. Gonzalez-Lopez, and I believe those are ready to be picked up. We just haven't had the ability really right today to go do that. So I'm assuming that those are going to be uploaded relatively shortly, and we can provide that to defense via e-discovery.
All right, and the visits, I'm assuming, were done by video?
Yes, Judge, that's my understanding.
And nobody knows how long those visits took place, correct?
No, Judge.
Do we have any idea or approximation of how many videos?
So in speaking to the detective indicated to us that there was about 3 or 4 visits concerning Mr. Gonzalez-Lopez. He said that they all varied in length. I don't think he ever gave a specific time as to how long each video or visit was. Did he, Kathy?
No, and I think that there were some other visits that Hank had requested too, so I think the total is going to actually...
The focus now shifts from the courtroom's initial surprise to the practical challenge of handling the newly discovered evidence. But beneath the discussion of logistics, a much deeper concern begins to emerge. The prosecution reveals that there are multiple jail visitation videos connected to the defendant, instantly changing the scope of the case. What initially sounded like a simple evidence review quickly becomes something far more significant. These aren't just a handful of short clips. They could contain hours of conversations and interactions that may prove critical to the investigation. As the volume of evidence becomes clear, both the prosecution and the defense recognize that reviewing it will take time and could dramatically influence the direction of the trial. With so much potentially at stake, what once seemed like a manageable case is rapidly growing more complex. Every video now carries the possibility of revealing information that could strengthen one side, weaken the other, or completely reshape the legal battle ahead.
Generally, my only concern is that I'm in the middle of preparing for a murder case that's, I think...
No, I will get... Yes.
So.
Well, I can tell both parties...
I just time to look at everything.
No, I'm going to give you all both time to look over everything and also schedule a trial date if that's what's decided. And I'm assuming the visitations, and this is assumption on my part, took place in Spanish?
Yes.
That's the assumption.
And so maybe there's a transcript needed, maybe not. And then there's the other issue of if he was presenting himself as an attorney, is that attorney-client privilege, even though he's not an attorney? So I think those are issues.
That's a definite no.
Yes. Yeah, no, he's not an attorney.
I would say that there is, I certainly don't think there's any privilege that would keep me from looking at things.
No. What I mean is, if, and this is just me asking a question, if somebody has case law on it because new things pop up, the question is going to be, what did your client say? And whether or not this person was holding himself out as an attorney. And
this is where the case takes an even more unexpected turn. As the discussion unfolds, the judge raises a critical legal question that immediately changes the focus of the courtroom. What if the person meeting with the defendant during those jail visits falsely presented themselves as an attorney? It's a possibility that no one had fully considered until now. That single question opens the door to a complex legal gray area involving attorney-client privilege. If the defendant genuinely believed they were speaking with legal counsel, the conversations captured on those recordings could potentially receive legal protection, even if the individual was not actually an attorney. Suddenly, the debate is no longer just about reviewing hours of jail visitation footage. It becomes a much larger question of whether some of the most important evidence in the case could be ruled off limits altogether. The answer could significantly influence the course of the trial, making this legal issue just as important as the evidence itself.
Because I would think that if you're speaking to your attorney, you would probably tell them things. Not saying that it would be anything incriminating. We just don't know.
Well, I just want to make sure that my client's rights are protected to the absolute fullest extent of the law, as I know everybody here is interested in doing, because that is our ethical duty.
Yeah.
So I think just giving us some time to look through those things to see if they're pertinent, and we can address it together once we all have a chance to look at everything.
All right. Well, off the record for a moment. This is what I think. And this is just me looking ahead. Depending on if this person presented himself as an attorney, then it may be items that the DA's office should not be looking at or looking to transcribe. So I would think it will probably be prudent on the state's part and everybody's part is if the items are obtained, for the state not to look at them until it's determined if this person was saying, I'm your attorney. And then everybody look into case law on what makes attorney-client privilege. If you're dealing with someone who's not actually an attorney and you assume that they're an attorney, does that still give you attorney-client privilege? And it may be something that the state should not.
At this stage, the defense shifts its focus toward one priority above all else: protecting the defendant's legal rights. The discussion becomes noticeably more careful and strategic as both sides recognize that the issue extends far beyond simply reviewing evidence. Every decision from this point forward must be handled with caution to ensure that no constitutional or legal protections are compromised. As the conversation continues, everyone in the courtroom acknowledges the significance of attorney-client privilege. If that privilege is found to apply, even unintentionally, the consequences could be substantial. Evidence that seemed essential moments earlier could suddenly become inadmissible, fundamentally altering the course of the case. Proceedings. Both the prosecution and the defense begin preparing for a much deeper legal battle, one that reaches beyond the facts of the case and into the complex interpretation of the law itself. The atmosphere in the courtroom changes accordingly. What began as a routine procedural discussion evolves into a broader legal debate centered on protecting due process and preserving the integrity of TH.
Potentially, I would be more than happy to go ahead and I think the same goes for Mr. Leal with his client. We could review those, and if we do think that there's an issue, we could certainly bring that to the attention of the court.
All right, we're back on
review.
Okay, all right, we're back on the record. These are my thoughts. If you all obtain all the information, and if both parties want to put it under seal, I'll review it. Of course, I'll have to have an interpreter. And if I review it, and if it appears that that person is presenting themselves as an attorney and as his attorney, and then I will let you all know this is what has happened. This person has presented himself as his attorney, then everybody can file whatever motions they want to file as to whether or not the state should have privy to that.
I would feel much more comfortable with it going to you, even if it has to be transcribed or translated, and then you making that call, because I think that puts the responsibility, I guess, that heavy burden where it needs to be as far as making any calls on who gets what.
All right. And so just so everyone know, the part that I'm going to listen to is whether or not this person meets with your client by video or in person and presents himself as his legal attorney.
Yes, Judge.
And then once that's determined, I will let you all know. He says he's his legal attorney. Then you all will do research.
The judge now takes control of the situation, introducing a clear and decisive plan to address the growing legal uncertainty. Rather than allowing either side to risk mishandling potentially sensitive evidence, the court decides to review the jail visitation footage privately. By keeping the process under the court's direct supervision, the judge aims to ensure fairness, prevent bias, and protect the integrity of the proceedings. With that decision made, the judge narrows the issue to a single, critical question. Did the individual in the recordings present themselves as the defendant's attorney? Before anyone else can examine the footage, the court must first determine whether those conversations could be protected under attorney-client privilege. The answer to that one question could have a profound impact on the case. If the court finds that attorney-client privilege may apply, key portions of the evidence could be excluded from the trial. If not, the recordings may become available to both sides. What began as a routine review of newly discovered evidence has now evolved into a pivotal legal decision that could shape the entire course of the proceedings.
And Judge, what I was going to do, because I did request the visits for Mr. Leal's client as well, I took that step. What I was going to do is see if our investigator can go through sort of the same process that he did on this case, because my understanding is that they're supposed to be put on a flash drive.
Yes.
And then he's just going to pick them up. So I'm going to see, I emailed about Mr. Leal's client maybe about an hour and a half ago. So it might just be easier just to say, hey, can you just do the same thing?
All right. And Mr. Leal, could you state your name for the record, please?
Rafael Leal.
And Mr. Leal, you're representing
Juan Velazquez.
and cause number 2022 CR 10958B. Is that correct?
Correct.
And he's also in custody and he's in the courtroom.
Yes, sir.
So it's the court's understanding then that neither defense attorneys would have an objection to the state not reviewing the videos that this person may have had with your clients, the video visitation on video or in person, that I will receive the evidence that they have. I will have an interpreter and it transcribed to see whether or not this person presented himself as the attorney of your client, Ms. Compton, and your client, Mr. Leal. And once that's determined, then you all will have to do your research. I will do my research, and it'll become a question of whether or not attorney-client privilege was.
As the hearing continues, the situation becomes even more complicated when another defendant is brought into the discussion. What initially appeared to be an isolated issue now seems to extend beyond a single case, raising concerns that multiple clients may have been involved in similar interactions with the same individual. The scope of the legal question suddenly grows much larger than anyone anticipated. Recognizing the potential consequences, everyone in the courtroom rallies behind the judge's cautious approach. Both the prosecution and the defense agree that no one should review the jail visitation footage until the court determines its legal status. By preserving the integrity of the evidence, they hope to avoid compromising any potential claims of attorney-client privilege. With more typal proceedings, what happens next may not only determine the admissibility of the recordings in this case, but could also shape the handling of similar evidence in the others that Han one case potentially affected. The stakes rise considerably. The court is no longer dealing with a single evidentiary dispute, but with a legal issue that could influence multiple.
To that from either defense attorney.
No objection from my side, Judge. I only have a question. Has those videos been reviewed by anybody, any detective who understands the Spanish language, or anybody else in the district attorney's office? That would be my only question. Perhaps they have already reviewed those things
May
at
I
this
speak
point.
to that, Judge?
Yes.
So my understanding is that the assigned detective to the case involving Mr. Berrocal attempted to review. However, he does not consider himself to be proficient in Spanish. He speaks some Spanish. So he communicated to both Daniel and myself that he was not able to say with any certainty what the conversation
All right.
contained.
So state, I understand that there may potentially be charges against this person for perhaps presenting himself as an attorney But if you could let the detective know that they're not to review those tapes as they relate to this case. Any detective who's involved in this case or officer who is involved in the case out of this court is not to review those.
Okay.
That it will be sent to me, and I will review those and do in camera.
Does that include members of the district attorney's office?
Oh, you were not here for that discussion. The district attorney's office is not going to be reviewing that. I will review it, and if either party says, you're my attorney, or this person presents himself or has presented himself as the attorney for your client or Ms. Compton's client, that's all I'm going to listen to. And then I will let you all know that he presented himself as an attorney. Then the next question is going to be whether that's enough to establish attorney-client privilege when in fact this person is alleged not to be an attorney.
And if it turns out that you don't find anything like that, then I'm assuming at that point it'll be released to everyone.
Yes.
Okay, sounds good to me.
And Judge, I found the detective, his email in my address book. I was just gonna send him an email.
All right, thank you.
All of us.
Yes.
Judge.
Thank you. So, Mr. Leal, that's the court's proposal. Ms. Compton is in agreement with that. Are you in agreement with that?
Yes, Your Honor.
All right. So, my understanding is that they already have the videos. So, let me see what date we can bring this back. And State, when do you think you'll be able to have the videos to the court?
That I don't know, Judge. I think it's more just scheduling with our investigator to go pick them up.
All right. So what I'm going to do then is I'm going to recall this case. I know that spring break is, I guess, the week of March 11th or the week of March 18th. Am I correct? Who has school-age children? All right. So we're going to recall this for March 4th. And on that date, that State March 4th, is that enough time for it to be given to me? All right, so March 4th, just so everybody is clear, the only thing is going to happen on that date is you all going to come in at 9 a.m. and we're going to make sure that I have the videos and have whatever documentation of the visitations that happen at the jail. All right?
Yes, Your Honor.
Is there anything else from either side?
Not from my side, Judge.
Not at this point, Your Honor, no. Thank you.
All right. And Mr. Leal, you're fluent in Spanish?
Fully, yes.
All right. If you will please let your client know, because we didn't have 2 headphones for each client.
I'll let him know, Judge.
All right.
As the hearing approaches its conclusion, one final revelation adds yet another layer of complexity to the case. It comes to light that someone had already attempted to review the jail visitation videos, but language barriers prevented them from fully understanding what was being said. That discovery raises fresh concerns about how the evidence has been handled and reinforces the need for a careful, impartial review. Recognizing the potential legal implications, the judge responds decisively. To protect the integrity of the proceedings, the court orders that no one involved in the case should access the recordings until the legal questions surrounding them have been resolved. The next hearing is scheduled, giving the court time to examine the evidence under the proper safeguards before any further action is taken. For now, the case is placed on hold, but the uncertainty remains. Everyone leaves the courtroom knowing that the contents of those recordings could significantly influence what happens next. Until the court determines whether the conversations are legally protected, the most important evidence in the case remains sealed behind unanswered questions. If you found notifications so you don't miss our next in-depth look at the most compelling legal cases and courtroom moments as Courtroom Breakdown insightful, be sure to like the video, subscribe to the channel, and turn on noti.